Welcome to the fourth episode in our video series about the Founding Fathers of the United States of America. Now, if you've been watching the first few episodes, you know that this video series is not some dull and boring recitation of facts. No. We are having some fun here. We are considering the context of the time and the situations that confronted our founding fathers. And as a result, we are really getting to know our founding fathers as people, who they really were as human beings. And we're also gaining a wonderful appreciation of the fascinating story of the founding of this nation. So let's pick up our story where we left off last time. So in episode 3, we learned about the Constitution. We learned about what was in it and what it was all about. And we also learned how these founding fathers created it right here in this room in Independence Hall in Philadelphia, Pennsylvania. So at the end of episode 3, our founding fathers had finally put the final touches on a draft of the Constitution, but they had not yet sent it out to the states for the states' approval. So at this point, we do not know whether this Constitution is going to be approved by the states. So let's pick up this story there and jump right into episode 4. After 4 long months in this room of grueling debate and negotiation and drafting and redrafting, the delegates to the Constitutional Convention finally put the finishing touches on the Constitution of the United States. They crossed all the T's, they dotted all the I's, and bam, there it was, the Constitution. Now, the Constitution was not effective. There was still one more step that needed to be accomplished before the Constitution could become effective. And that is that the Constitution needed to be ratified or approved by the states. So the Founding Fathers then sent this Constitution out to the 13 states for their consideration and hopefully their ratification. So the Founding Fathers then sat back, crossed their fingers, and hoped that the states would ratify the Constitution and thereby create this federal government. Now, it's kind of hard to imagine today, but back then, this was by no means a sure shot. Okay? There was a lot of opposition to the Constitution. Right? So remember, the states, they viewed themselves as independent sovereign nations. Okay, so they, many of them were very reluctant to give up some of their own sovereignty to some new federal government. They were very wary of that. They suspected it would be like just another, sovereignty like they had in Britain, the British crown, and it would be the same thing all over again, the monarchy. So it was by no means a sure thing that this Constitution would be ratified. So shortly after they sent the Constitution out to the states, all of a sudden, these newspaper articles started appearing that were opposed to ratification. So these newspaper articles were written saying, let's not approve the Constitution. So this was very alarming to a number of the Founding Fathers. In particular, it was alarming to Alexander Hamilton. Now remember, Hamilton was a writer himself. Back in the Revolution, he was writing newspaper articles trying to encourage people to join the Revolution and seek independence. So Hamilton knew the power that newspaper articles could have in influencing public opinion. So Hamilton sprung into action. And his idea was, he's like, look, we've got to create our own newspaper articles. So he goes out and recruits some of his buddies, but it ended up being primarily Hamilton and James Madison. So these two guys team up and they start writing newspaper articles, one after the next. And the purpose of the newspaper articles was to explain the Constitution, explain what they did, explain why they did what they did, and then try to persuade the public to ratify the Constitution. So article after article, one after the next, and this went on for about a year, and they ended up writing about 85 articles. Okay, so these articles, this collection of articles, became known as the Federalist Papers. So these are the famous Federalist Papers. So they're called Federalist because the idea of the Constitution was creating a federal government, a new federal government, and these papers were advocating for ratifying the Constitution. So Federalist Papers in favor of creating a federalist government. So these papers were amazing. So they ended up being numbered. So Federalist number 1, Federalist number 2, Federalist number 3, all the way from 1 to 85. And almost all of them were written by either Hamilton or Madison or both of them combined. Now, a few of them, 3 of them, were written by another guy, John Jay, one of their colleagues and also a founding father, but most of them were written by Hamilton and Madison. And Hamilton wrote most of them. Hamilton wrote 51 of them, and Madison wrote 26 of them. And then on 5 of them, Hamilton and Madison teamed up and combined to write these additional 5. So Hamilton, you know, this guy who was advocating for a strong federal government. Madison, who was the father of the Constitution. Remember, Madison was the brains behind this whole thing. They start writing these articles. So it was amazing. So each one of these Federalist Papers, like Federalist number 1, number 2, number 3, each one of them was pretty much centered around one particular idea or a couple of ideas. So they were pulling out an idea and then explaining what they did and why they thought it was a good idea. So, for example, Federalist number 10 was written by Madison, and in that he was explaining the dangers of factions, of political factions, what we would now think of as political parties. And Federalist number 51, also written by Madison. So Madison explains the checks and balances that they wired up into this Constitution. And in Federalist number 70, Hamilton makes the case for why we should have a president. Right? Having a president was actually a concern to many people back then because they thought it was just like having another king of England, which was a problem. So Hamilton makes the case why having a president was actually a good idea. And Federalist number 84, Hamilton explains why a Bill of Rights was not necessary. All you needed was a Constitution, and you didn't need a separate Bill of Rights. So you could see these Federalist Papers were sort of centered around ideas, and then in those papers, these guys would explain what they did and why they did it, and encourage people, so everything's fine, this all works, this is a great idea, so all you states out there, you should ratify the Constitution. Now, these Federalist Papers are just amazing. They are a treasure of history. I mean, you think about it. Not only do we have this Constitution, which is pretty amazing, right? This first Constitution that creates the first democratic government where people could elect their own form of government. That's pretty amazing in and of itself. But in addition to that, we also have these very same founding fathers who created it writing 85 articles for public consumption explaining what they did and why they did it, why this provision is in the Constitution, why it's set up this way, why we did this. I mean, it is amazing. It is a treasure of history that we have these Federalist Papers. It is wonderful. So this went on for, a year, just about a year of them, of Hamilton and Madison writing these articles and explaining the Constitution. Now, while this was going on, while they were publishing their articles, there were other people who were opposed to the Constitution who were also publishing articles. But they were publishing articles from the opposition of, why we should not do this. So this is amazing, right? So now what we have today is we have a collective set of these papers. So we have the set of, on the one hand, the Federalist Papers written by Hamilton and Madison saying why we should ratify the Constitution. And then we have another set of papers in opposition written by a whole bunch of different people explaining why we should not ratify the Constitution. So this set of papers became known as the Anti-Federalist Papers. So we have the Federalist Papers and the Anti-Federalist Papers, and it's just wonderful to compare these two papers, reasons for and against, back and forth. It is an amazing set of papers, and you can now buy them, together and have a nice set of the papers. So it is a wonderful thing. So you've got this raging debate going on now. All these people are publishing these articles, right? Some for, some against. So these 13 states are debating this and struggling with this question, but it was still not a sure shot. It was not clear whether this Constitution was going to be ratified. Perhaps the biggest problem that these states were having with the Constitution was that it did not include a Bill of Rights. Okay, so what they were saying is, look, we, the states, we are having a hard time ratifying this Constitution because it doesn't have a Bill of Rights in it. So this was a huge problem because this was a potential threat here that the Constitution would not actually be passed. So why didn't the Constitution include a Bill of Rights? Well, it's actually kind of funny because our founding fathers, the delegates here at the Constitutional Convention, they actually did think of it. So what happened was, after the Constitution was drafted, somebody said, hey, why don't we include a Bill of Rights? And they said, look, this is a good thing because we know that some of the states will want to see a Bill of Rights. So if we put a Bill of Rights into the Constitution right from the beginning, this will make it more likely that the states will ratify the Constitution. So let's put one in. So everyone said, yeah, sure, okay, fine, let's put a Bill of Rights in. But then some people said, listen, we do not have time to put a Bill of Rights in. We don't have time to create an entire new Bill of Rights. We've been at this thing for 4 months now. We have a Constitution. We don't have time to start from scratch creating an entire new Bill of Rights. But others said, no, come on, it'll be easy. It'll be simple. We'll just whip one up, slap it on. It'll only take, a few hours, maybe a day. That's it. So, people said there's no way it's going to take, it's going to be that easy. It is a very complicated thing. No, it'll be easy. Come on, let's try it. Okay, you want to try it? Go ahead, try it. So they gave it a whirl, but almost immediately it became very clear that this was not going to be some simple and easy process, that it was going to open a whole new can of worms and take a long time. So, and the reason was because, this whole constitutional process took a long period of time, right? The way it worked was, somebody would propose something and then everybody else would have their own take on it. So some people would be in favor, some people would be opposed. Then people would come up and let's say, let's modify it. Let's do it this way instead of that way. Let's add this, take out that, right? So then they had to negotiate the whole thing. And then once you started to write it down on a piece of paper, everyone wanted to read it, and then everyone had comments and everyone had changes and, and then thought of new ideas. And it was just a meticulous and an extremely excruciating process just to do this Constitution. So to now start something new, it became clear to everyone that it was opening another can of worms. It would just take a long time. So it's kind of funny, but the reason that we do not have a Bill of Rights, the reason we did not have a Bill of Rights in the original Constitution is because the founding fathers here at the Constitutional Convention were too tired. They were worn out and they were ready to go home. So that's pretty funny. So what was the Bill of Rights? What is this Bill of Rights thing, and what is it all about? So what the Bill of Rights is it is a protection for the states or for the people. It was incorporated to the people. It was a protection against the power of the federal government. So the idea is that in this Constitution, the people were creating a federal government and giving the federal government power. So, but the concern when you give the federal government power is that you don't want that federal government to be able to use that power against you in ways that you didn't anticipate. So it was sort of like a shield. The Bill of Rights was sort of like a protection against the federal government using this power against you in ways that you didn't anticipate. So you can think of the federal government as, or sorry, the Constitution as sort of an affirmative document, that it grants power and it creates the federal government, creates power. So it creates the presidency, it creates the Senate, creates the courts, creates power. But then the Bill of Rights is in the negative. So it says, even though I've given you this power, you cannot use this power to do these things to me. And then it lists these things. Bill of Rights is like a list of rights. So even though I've given you this power, you cannot do these things to me, this list of rights. So it's like a list of protections. So this is why this was so important to the states, because remember, the states were viewing themselves as these, sovereign nations. And to sign on to this Constitution meant they were giving up some of their sovereignty to this new federal government. So what the states were saying is, all right, we'll give you this power, but we need a Bill of Rights to be sure that you're not going to turn around and use it against me in ways that I'm not anticipating. So this was the issue with the states and the Bill of Rights. This is why the states wanted the Bill of Rights. So the Bill of Rights is amazing today. I mean, when we think of the Constitution today, the things in the Bill of Rights are some of the things that we hold the most dear in the Constitution, right? We think of them as the essence of the Constitution. So if you went out on the street and asked somebody, what are the most important things in the Constitution, it's a pretty high likelihood that they would start listing things that are in the Bill of Rights, not in the Constitution, but in the Bill of Rights. So what they would start listing are things like freedom of speech, right? Freedom of the press, freedom of religion, the Second Amendment, the right to bear arms, the right to be free from unreasonable searches and seizures without, probable cause and a warrant, right? So these are like fundamental things. The right to not incriminate ourselves, right? This is the Fifth Amendment. So I plead the Fifth. To plead the Fifth Amendment means you can't be forced to testify against yourself. You can't be forced to admit that you did a crime, right? The Fifth Amendment. The right against cruel and unusual punishment in the Eighth Amendment. All these things are in the Bill of Rights. They are not in the original Constitution. Now, the Bill of Rights is part of the Constitution because it's their amendment, so they amended the Constitution, but they were not in the original Constitution. So it's pretty amazing, and you can see why the Bill of Rights sounds like a good idea, right? These sounds like some pretty good protections, and in fact today, and the body of constitutional law that we now have, it turns out that wow, these Bill of Rights were pretty important. So this is what the states were saying. So the states were saying, look, we need this Bill of Rights. We are very reluctant to pass this Constitution without a Bill of Rights. So this caused a huge problem for the Federalists, for Hamilton and Madison. These are the people who wanted to create the federal government, right? All of a sudden, their idea, this Constitution, their idea of the Union is in jeopardy because the states, it's looking like the states will not pass the Constitution because it doesn't have this Bill of Rights. So Hamilton and Madison, they start to argue that, look, you don't need a Bill of Rights. Okay, it's not necessary. So they wanted to persuade the states to ratify the Constitution without the Bill of Rights. So they started making arguments to the states as to why the states didn't need the Bill of Rights. Okay, so one of the reasons that they were pointing to is they were saying, this is Hamilton and Madison, they were saying, look, it's completely unnecessary. A Bill of Rights is unnecessary. It's like a worthless piece of paper. So why? Why would the Bill of Rights be unnecessary? And the reason is what they were saying is, like, all the rights that the federal government has is contained in the Constitution. Okay, it's right there. It lists the rights that the federal government has. You don't need a separate list listing the things of the rights that the federal government doesn't have because you already have a list of the rights that the federal government does have, right? So it's just a wasted piece of paper to list the things that the government doesn't have. It's a waste of time. So just for example, to think about this, so with a concrete example, so let's say that you hire a plumber to come in to fix your leaky faucet. So you enter into a contract with the plumber that says you can come into my home to fix my leaky faucet. So that contract with the plumber is like the Constitution. You're giving the plumber the right to come into your home. Okay, so you can come into my home to fix my leaky faucet. So that contract with the plumber is like the Constitution. It's an affirmative right. So what Hamilton and Madison would say is, you don't need a Bill of Rights with the plumber. You don't need to list all the things that the plumber doesn't have the right to do, right? Like, you don't need to list, okay, plumber, just because I'm letting you in to fix my leaky faucet, you don't need to list, plumber, you do not own my home. Plumber, you cannot live in my home. You cannot raid my refrigerator and eat my food. You don't need to list all those things that the plumber cannot do, because it's obvious, and you never gave the plumber the right to do those things in the first place. The only right you gave the plumber was you can come into my home to fix my leaky faucet. So you don't need a separate list of all the things that the plumber cannot do. It's silly. It's just a wasted piece of paper. So that is what Hamilton and Madison were saying, is the state to the states. This is why you don't need a Bill of Rights. So that was one argument. Another argument they made is it's also dangerous to create a Bill of Rights. In fact, states, it will cause you more problems than benefits. Okay, why? Why is it dangerous to create a Bill of Rights? So what they said, what Hamilton and Madison said was, they said, look, if you create a Bill of Rights, this suggests that in fact the federal government does have more rights that are not included in the Constitution. And that is a dangerous suggestion to make, right? So they're saying the very suggestion in and of itself, the fact that you felt that you needed to create a Bill of Rights, suggests that this list in the Constitution that the powers of the government had was not comprehensive. That in fact the government did have rights outside of the Constitution, that they could do all sorts of things to you that were not included in the Constitution. And they said that is not a good precedent to set. You do not want to do that. You don't want to create that suggestion. So that's the reason why you don't want to create a Bill of Rights. And another reason why you do not want to create a Bill of Rights is because, so the Bill of Rights is a list of these things that the government cannot do to you, right? The government cannot infringe your freedom of speech. The government cannot infringe your freedom of religion. The government cannot take away your right to bear arms. You know, it's a list of things the government could not do. So what Hamilton and Madison said was, look, it is dangerous to create a list like that of the things that the government cannot do, because that suggests that this list is comprehensive. So if you're going to create a list of the things the government cannot do, you have to put everything in the world on that list, right? There has to be millions of things on that list. You have to list everything that the government can't do. Because if you only list a few of the things that the government can't do, you are creating the implication that anything that's not on this list, the government can do. Okay, and you don't want to do that. That is a bad thing. So, you know, the analogy of the plumber, right? So if you create a Bill of Rights for the plumber, okay, plumber, you can come into my home to fix my leaky faucet, but you do not own my home. You cannot live here. You cannot raid my refrigerator. 3 things on that list, very clear. Okay, that's all clear. But that means that anything that's not on this list, the plumber can do. Okay, so the plumber can go and raid your closet and, you know, take all your clothes and go and play your video games and take your CDs and, you know, basically have the run of your entire house. So long as it's not on this list of prohibited things, the plumber can do whatever the plumber wants in your house. Okay, and that is the danger. That's what Hamilton and Madison were saying. That's the danger with creating a Bill of Rights, because if you list these certain things that the government cannot do, okay, fine, they can't do these things, but they can do anything else that's not on the list. And you do not want to create that impression. That is a dangerous precedent to set. So that is the argument that that Hamilton and Jefferson made to the states to try to persuade the states so that they should ratify the Constitution, and they did not need a Bill of Rights. So that's what the Bill of Rights was, and that's what the issue with the Bill of Rights was all about. The fact that there was no Bill of Rights included in this Constitution was becoming a real problem, because a number of these states just could not bring themselves to ratify the Constitution without the protection of the Bill of Rights. So a number of these states started sort of creating these grumblings that what they were thinking about doing was ratifying the Constitution, but only if the Constitution included this Bill of Rights, and then they would attach a draft of the Bill of Rights. So they'd write their own Bill of Rights and attach it and say, if you include this Bill of Rights, then we approve. But Madison and some of these other founding fathers said that is a no-go. No way. So they said, look, the only thing the states can do is vote yes or no, an up or down vote. That's it. You states, you cannot make any amendments, you cannot make any changes, you can't make any alterations, and you can't make any conditions. So you can't attach your own Bill of Rights and say you approve only if those Bill of Rights are included. No. All you can do is vote yes or no. And this makes sense, right? Because, if the 13 states were all allowed to, propose amendments and make changes, it would just create a big can of worms. It would be a mess, right? Because, think about it. This is what had gone on in the Constitution. It took these guys 4 months to come up with this draft. And that was the purpose of coming up with the final draft. So if you allowed these 13 states to make changes and amendments, well, everybody's going to make changes and amendments, and it's just going to be a big mess, and the whole thing's going to collapse. So the idea was, nope, you cannot make any changes, you cannot attach a Bill of Rights, you can only approve yes or no. And this actually is a technique that we see today. It's a common technique. So, for example, we see it in like trade agreements. So when the President of the United States negotiates a trade agreement with other countries, foreign countries, they will finalize the draft of the agreement. Then they will send that final draft of the agreement to Congress for Congress to either vote yes or no. But Congress does not have the ability to make changes or amendments. It's either yes or no, up or down vote. That's it. So again, this makes some sense because, if you allow amendments and changes, then you're renegotiating the agreement, opening a can of worms, and it just leads to a whole bunch of administrative problems. So this technique was in effect back 200 years ago. They were using it as well. So Madison and these other guys said, nope, can't make any changes. And if any state tries this, so if any state says, yes, we approve, but only if you incorporate our Bill of Rights, that will be deemed a no vote. So that would be deemed a vote against ratification, against the Constitution. Now, the states were under a lot of pressure here, and this put a lot of pressure on the states to vote yes, right? Why? Because there was no alternative. What was the alternative? If the states voted no, that would risk tanking this whole thing, tanking the Constitution, tanking this whole idea of forming a union, and you'd be back stuck with the Articles of Confederation that nobody was happy with anyway. So, it was a very difficult decision to vote no, because you were, basically stopping, this government. In some respects, it was better to vote yes and accept this government, even if it wasn't perfect, because at least you weren't going back to something that you knew was not working. So there's a lot of pressure on these states to vote yes, but at the same time, a number of these states just were having a hard time swallowing this pill of accepting the Constitution without the protection of the Bill of Rights. So finally, the state of Massachusetts comes up with an idea to break the logjam. And this idea was actually, principally, the guy behind it was John Hancock. So this is another one of these founding fathers, John Hancock. So the idea from Massachusetts was, look, why don't we do this? Why don't we approve the Constitution? So we will ratify the Constitution, but with the recommendation that the government immediately implement a Bill of Rights. Okay, so it was a recommendation. It was not binding. It was not a condition. They were not attaching it. They were just saying it was a recommendation. So their vote was a yes. So their vote was, we, Massachusetts, vote to ratify the Constitution, but just to be clear, we are writing in the same document that we ratify. So when they say we ratify, they're writing in, we recommend creating a Bill of Rights immediately. So even though this recommendation was not binding, it was only a recommendation, it still carried weight because the implication was that Massachusetts was expecting the government to create a Bill of Rights, and that if the government did not create a Bill of Rights, there'd be problems. Massachusetts was going to cause some problems. So even though this solution wasn't perfect, it was sort of a compromise, middle of the road solution. So Massachusetts put it to a vote internally to see what would happen in their state, and it worked. So their state voted to pass and ratify the Constitution, along with this recommendation that the government immediately implement a Bill of Rights. So it worked, but the vote was a squeaker. It was a close vote, right? It's amazing. So the vote was 53%. That's it. The Constitution passed in the state of Massachusetts by only 3%. 53% of the people voted in favor of it. I mean, it's amazing to think how close this vote was. But nonetheless, the Constitution now was ratified in the state of Massachusetts. So some of these other states that were also having a hard time swallowing this pill of not having a Bill of Rights, they looked to Massachusetts and said, you know what, that's a pretty good idea. Maybe we should try that same idea in our state. So a number of these other states did the same thing. So they suggested that they would ratify the Constitution, so a yes vote on the Constitution, with the recommendation that a Bill of Rights be quickly created. And it's worked. So a number of other states did the same thing, and pretty soon a number of other states were ratifying the Constitution, some of them based upon this idea that from Massachusetts. But again, it was amazing how close these votes were in some of these states. I mean, it's just amazing. So New York passed it by 53%. Virginia, the huge state of Virginia, passed it by only 53%. New Hampshire, 55%. Right? So it is amazing. I mean, you think about it. You know, today we think about our government like, oh yeah, America won the revolution and then created this federal government. No. That is not the way it happened. It was a close vote. And in fact, it was almost the case that the Constitution almost did not even pass. Right? A number of these states, it just squeaked by. So that just shows how divided the country was and how controversial this was to create a federal government. Right? It's amazing today, but that is how it happened. Right? Pretty remarkable. So a number of these states now are going along ratifying the Constitution, but then the question comes up, well, how many states do you need to ratify in order for the Constitution to become effective? Well, the Founding Fathers, the Constitutional Convention, provided an answer to this. When they sent the Constitution out, they said, we need 9 states. So 9 out of the 13 must ratify it in order for it to become effective. And when you think about this initially, you think, you know, 9 out of 13, that's 70%. So that's, you know, pretty high vote, supermajority vote, pretty high, but sounds reasonable. You know, why not? Sounds like rational idea. But then you think about it a little further. You think, well, wait a minute. What about the Articles of Confederation? Right? Because the Articles of Confederation are still in existence. Right? The 13 colonies agreed to these Articles of Confederation, and this Constitution was meant to replace the Articles of Confederation. But until the Constitution takes effect, the Articles of Confederation are still what governs. So don't you have to look to the Articles of Confederation to determine how many states are required to ratify this? And you sort of do, right? So what happens when you look there? Well, when you look to the Articles of Confederation, what they say is it requires a unanimous vote. It requires all 13 states to vote in favor of the Constitution. Otherwise, the Articles of Confederation cannot be amended or changed or replaced. Right? So the fact that these Founding Fathers kind of said, you know what, that's too high in the Articles of Confederation. We're not sure we can get all 13. So let's lower it to 9. Okay, where do they have the authority to do this? They really didn't. Right? They just kind of made it up. It was somewhat of a radical act because they were overriding the provisions that were in the Articles of Confederation. It's amazing. But nonetheless, that's what they did. So when they sent it out, they said to the states, we need 9 votes. So as these states started ratifying one after the next, pretty soon 9 votes came in. And then after that, 2 more came in after that, pretty close. So you had 11 votes. And this took a year. So this was 1 year later, after they had sent it out. So after the Constitutional Convention finished the draft of the Constitution in 1787 and sent it out to the states, the 13 states, 11 of those states had approved the Constitution 1 year later in 1788. So based upon the ratification of those 11 states, the Constitution was declared effective. The United States Constitution takes effect. Amazing. Now, you might be thinking to yourself, well, what about those other 2 states? Right? What happened to the 2 states that did not ratify? Well, the 2 states were Rhode Island, naturally, since Rhode Island, right, they were objecting to everything. In fact, Rhode Island was the only state who refused to send any delegates to the Constitutional Convention. So no surprise there. Rhode Island didn't like the whole process, so they did not ratify. And the second state was North Carolina. North Carolina also did not ratify. So the reason that they gave was they said, look, we want a Bill of Rights. And this idea that Massachusetts came up with writing in a recommendation, that's not good enough for us. A recommendation is non-binding, and that's not good enough for us. We want to see a Bill of Rights. So based upon that, those 2 states did not ratify the Constitution. So what ended up happening? Well, when the Constitution was ratified, these 11 states came together and they started creating the government. So the 2 states that did not ratify were being excluded. So in the very first presidential election, Rhode Island and North Carolina were excluded from the vote. They could not participate in the vote because they hadn't ratified the Constitution. And then these other states are forming Congress. So these Congress persons are being elected to Congress and sent to Congress. But these 2 states, Rhode Island and North Carolina, could not send anybody to Congress because they hadn't ratified the Constitution. So pretty soon, this government is beginning to do things and take effect, and these 11 states are beginning to move the government forward and leaving these other 2 states behind. So these other 2 states start to soften. So about a year later, although they waited until the draft of the Bill of Rights had been completed and sent around. It was not voted on yet, so it was not approved or ratified yet, but at least it had been drafted and at least it had been circulated. So a year later, North Carolina cracks. They finally surrender and say, okay, fine, we ratify the Constitution. So this was in 1789. And then Rhode Island held out for a little while longer, and the following year, they ratified too. So they cracked too. They finally said, okay, fine, we surrender, we ratify too. So eventually, all 13 of these states ended up ratifying the Constitution. Now, it did not include a Bill of Rights. The original Constitution did not include the Bill of Rights, but nonetheless, it was ratified. So here we have the United States Constitution takes effect. So now, with the Constitution enacted, the focus turned to creating this new government. And the question became, well, what should we be doing here and what should we be doing first? So some people said, well, let's create this Bill of Rights. Now remember, this is what a number of these states wanted when they voted to ratify the Constitution. They said, we recommend creating a Bill of Rights. So let's create this Bill of Rights that these states want. Others said, nah, let's forget the Bill of Rights. Forget that. We don't need to do it. We don't have to do it because it's not binding, right? Those states that wrote in the recommendation, it was only a recommendation. We're not obligated to do it, so forget them. Let's not do it. And the reason that we shouldn't do it is because we have so many other things that we need to do that are so much more important, right? We don't need a Bill of Rights. We already have a Constitution. Bill of Rights is not necessary. So let's do all the other things that we really need to do. I mean, we need to, create all these departments in government, and we need to, create the entire court system. I mean, there's a whole bunch of stuff that we need to do here. We shouldn't be wasting our time creating the Bill of Rights that's not even necessary. Other people, however, said, no, we really should create the Bill of Rights. So one of these people who wanted to create the Bill of Rights, who was strongly in favor of creating the Bill of Rights, was this guy. Can you guess who? Can you guess who was leading the charge to create the Bill of Rights? Well, it was none other than James Madison. What? James Madison? Wait a minute. This was the guy who was totally against the Bill of Rights. Right? This was the guy, the father of the Constitution. He was the guy who drafted the Constitution and then said, you don't need the Bill of Rights. When all the states were threatening not to approve the Constitution, he said, no, you don't need it. Right? And he said, create all sorts of problems. So he has totally flipped now. Now he's leading the charge and saying, no, we really should create the Bill of Rights. I mean, it's amazing. So it is a total reversal here. So what is going on? Well, what Madison said was, he said, look, we really should do this because, you know, it's the right thing to do. The states want this. We know the states want this. And it was sort of implicit when the states ratified the Constitution, when they said we recommend, sort of an implicit understanding that we would in fact do it. So we really should do it. So that's a pretty good reason. Yeah, that's an honorable reason here, you know, sort of fulfilling the expectations of the states when they ratified the Constitution. So that's a good reason. But there were other politically expedient reasons to do it as well. So one was that, you know, there was a concern that the states might cause problems if they did not get this Bill of Rights. So one of the rights the states had, they still do today, is they had the right to call another constitutional convention. So just like this constitutional convention, the states have the right to call a constitutional convention. And if you call a constitutional convention, who knows what that could lead to? You could do whatever. You can amend the Constitution. You could scrap it. You could do whatever, right? So this was a threat here. So the concern was that if you don't deliver the Bill of Rights to these states, it could really cause a problem because these states could be upset, not happy with government, and they might even call a constitutional convention and really kind of screw things up. So by creating a Bill of Rights, you were basically heading off any sort of opposition movement. So that was a politically expedient reason for wanting to create a Bill of Rights. So another reason was that James Madison then, once the Constitution was approved, James Madison then ran for office. He ran for one of these new positions to be a congressman. So to join the federal House and the House of Representatives and represent the state of Virginia. So James Madison now all of a sudden he becomes a representative of a state, right? Before he was arguing for this strong federal government, right? Because he was just looking at it from an intellectual perspective of creating this you know, the best way to create the federal government. That's why he was all about creating a centralized federal government. But now he's representing the interests of a state, the state of Virginia. So perhaps he was thinking, you know what, maybe it would be a good idea for me to get some protections for my own state of Virginia by getting this Bill of Rights. So it's pretty funny. So he does do this reversal. So then the question becomes, okay, if we're gonna do this Bill of Rights, then who's gonna write it? Who should draft the Bill of Rights? And the natural choice was James Madison. Right, James Madison, he was the father of the Constitution. He was he drafted much of the Constitution. He was the brains behind it. So why not have him draft the Bill of Rights? So he gets appointed to do this. He says, okay, great. So off he goes to draft the Bill of Rights. And it's interesting. So what Madison ended up doing was he started with the existing draft of the Constitution. So the Constitution that was approved, he pulled out that draft, and then on that document, he started adding in, you know, a sentence here and a sentence there and a little caret and add in a phrase here and a phrase there, right? So he literally put the rights he embedded the rights into the existing text of the original Constitution. So when he was done with that draft, he circulated it to his colleagues in Congress, and they looked at this and they said, oh my gosh, this is so confusing and it's difficult to read, and you're changing the text of the original document. They said, no, you can't do it that way. You can't do it that way. They said, what you need to do is just create a separate document. So leave the text of the original Constitution alone as it was approved. Don't touch that. But then create a separate document, and in that separate document is where you put the Bill of Rights. So Madison said, okay, fine. So off he went, and that's exactly what he did. So the original text of the Constitution was left alone, and Madison created a new document named the Bill of Rights across the top, and then he started adding amendments. So amendments to the Constitution. So the First Amendment. And in the First Amendment, it included things like freedom of speech, freedom of religion. Then he added the Second Amendment. And the Second Amendment included the right to bear arms. Then the Third Amendment, the Fourth Amendment, all the way down. So he initially added 12 amendments, although only 10 were ratified by the states at the time. So that's what he did. So the Bill of Rights, that's what it was. So it was a separate document that merely contained the first 10 amendments to the Constitution. So that's what the Bill of Rights is. It's just a separate document that contains the first 10 amendments to the original Constitution. Pretty cool. So that's one thing that this new government did, is it created the Bill of Rights. And it took 2 years, but it was eventually ratified by the states and became effective.